Okay, Shannon, you can put us on. Hello, Chad. How are you?
Great, Your Honor. How are you?
Really good. Let me see. We just have the one file today, Ganton versus Washington.
Yes, sir.
All right, let me see who's there. All right, I've got one phone. Let me see who's there. It doesn't have a name associated with it, but it doesn't look like any of the other folks are here for this. Okay, and I know who this is, Mr. Smith. Okay, I had to open this up to see who was there, and clearly you're not on the case that I'm calling right now. So, Mr. Smith, correct? All right, I'm going to put this name on there so I know who you are, but I'm going to put you back in the waiting room. Okay, and it doesn't look like anyone else who has signed in. I don't see anybody with the last name Ganton or the first name Nicole, and nobody with the first name Clifford or last name Washington. So Mr. Washington is the payer in this file.
Yes, Your Honor.
All right, this matter was scheduled for a show cause hearing for non-payment of child support at 3 o'clock. It's now 3:06. Mr. Washington has not appeared. Would you like me to issue a bench warrant?
Yes, Your Honor. The bond will be cash only $1,461, which includes a $100 bench warrant fee.
Okay, go ahead and send that over. I'll be happy to sign it.
All right, great, Your Honor. Thank you.
Thank you, Chad. Have a good day.
You as well.
Okay, let's see. Looks like Stinson is next. Uh, Okay, looks like we have audio connection with everyone. This is Stinson versus Stinson. Counsel, state your appearances.
Good afternoon, Your Honor. Janet Hamilton on behalf of the plaintiff, Christy Stinson.
Good afternoon, Your Honor. Attorney Jennifer Payne, currently attorney of record for Jacob Stinson. However, he did indicate to me that he wishes to represent himself going forward. So I'm just logged in to make that part of the record and to ask for permission to withdraw and for him to represent himself for his request.
All right, and Mr. Stinson, you are fine with Ms. Payne withdrawing and you representing yourself at today's hearing?
I am, Your Honor.
All right, thank you, Ms. Payne. I will release you.
Okay, I'll submit an order to make that part of the file as well. Good luck to everyone. Take care.
Thank you.
Thank you, Ms. Payne.
Thank you.
Okay, I believe we are here on Mr. Stinson's parenting time complaints. Is that correct, sir?
Yes, Your Honor.
All right, let me see if I can identify what oh, I see I've got an answer. I didn't notice that earlier when I looked at the file. Give me a moment to just review this.
Yes, sir.
Okay. So, Mr. Stinson, with respect to parenting time complaints that were based on a misunderstanding as to which weekend was yours, I entered an order on November 12th. That addressed all parenting time complaints up to the point of that ruling. So the only complaints that would be properly before me today would be any that were filed after that ruling.
So, Your Honor, I'm not sure if there were a number of items that I had submitted to my previous attorney for that hearing that occurred on the 12th, which I was unaware of, that I'm not sure if you ever had an opportunity to see. So I finally did see your ruling. I was under the understanding that that hearing was going to take place or got moved to the 19th due to Attorney Hamilton's vacation plans or something of that nature. But if we could revisit that, I would really appreciate it, Your Honor.
Once I make a ruling, the only remedy for that ruling is a motion for rehearing or reconsideration, which must be filed within a specific time period, and you would be well beyond that time period. The only other remedy is an appeal. I don't go back and revisit items. You were represented by counsel of record. I appreciate that perhaps she wasn't communicating to you, or at least that's your claim. But at the time she appeared, she was representing you, and I addressed this specific issue on the record as to what was the proper start of your alternate weekends, and I issued a ruling. I am not going to go back and revisit that. What I can consider any parenting time claims that you filed after that. And I'm not sure, Ms. Hamilton, how many were there after that?
One that we know of, Your Honor, but we've not been served with everything. I did check with a friend of the court, and there is one dated November 6th, but it is based on the same claim that he's entitled to the opposite weekends that the judgment gives him. So it should be resolved by your November 12th order.
All right, hold on a minute. I do have some parenting time complaints that are attached. And the one clearly predates my order. It's for October 23rd through October 26th. I have one for September 25th through 28th, and that predates my order. I have one for October 9th through October 12th, which predates my order. One from August 28th through the 31st, and one from, wait a minute. Yeah, one from September 11th through September 14th. So the only ones I have are the ones that would have been encompassed by my last ruling. Let me see if there's anything else in here. So it would appear, Ms. Hamilton, you're in possession of one that I haven't seen.
It is, there's a typed date on it that says October 25th. And it refers to a November 6th start of parenting time. And it is based on the exact same complaint as the ones that you ruled on October 15th. Incorporated
And
into the 12th, the order on the 12th.
So it encompasses a weekend that I've already ruled was the mother's weekend?
It does, yes.
Okay. If those are the only parenting time complaints, there isn't anything for me to address today, is there?
One thing that I'd like you to just note for the record, that particular parenting time complaint was filed and served on us after the order was entered.
So then I think we should talk
Right.
about that.
But it's based on the same, it's the same pattern, sorry.
I clearly can talk about that. So, but Mr. Stinson, based on my prior ruling, that is a weekend that was, we've already determined, I've determined in a court order was the mother's weekend. So how can I entertain a complaint by you for being denied parenting time on a weekend that I've already determined is the mother's weekend?
So Your Honor, I guess I'd be curious to know how we determined that was her weekend and all of those parenting time complaints and time that I've been denied with my son now since the beginning of the school year. I wasn't a part of the conversation, was never able to provide my evidence, either way. So understood your judgment, Your Honor. I understand. However, I think I've got substantiating evidence that kind of shows the other way.
Well, let me ask you, so you've been appearing and requesting parenting time on weekends that I've determined are the mother's weekend, but you've not been appearing and requesting parenting time on the weekends that are necessarily determined to be your weekends?
Not all of the weekends that you have now determined are mine. So every weekend since the beginning of the school year, I have arrived to pick my son up, and his mother has pulled him out of school or kept him out of school entirely in order to deny me time. Weekends that you have now ruled were mine, some I have attempted and some I have not. And the reason for that, if I may, is that Ms. Stinson has used that one clause in our order that says that our communication should be kept to exchanges and medical emergencies as a no contact order and refuses to co-parent with me. There is no discussion whatsoever. So all I have to go off of as far as which weekends are mine throughout the school year when my parenting time resumes is past practices. And the precedence has been set over the course of the 2018-2019 school year and the 2019-2020 school year. Now we're in the 2020-2021 school year, and it changes to the degree that I have now been denied 7 consecutive weekends with my son. Miss Stinson has made no attempt to allow me parenting time or give Lucas time with his father. There's been no discussion, and at the end of the day, the person that suffers the most is my son.
So let me ask you,
Yes, Your Honor.
During this entire time period when you believed that her weekend was actually yours, there was no communication between you and her as to which weekend was yours and which weekend was hers?
She sent me a text message stating that I was wrong and that I didn't understand the order. And furthermore, she sent me a text message alluding to the fact that Lucas's parenting time schedule must match her other 2 previous parenting time schedules, which is nowhere to be found in our judgment of divorce. So, that's very simple.
So
I'm sorry.
let me stop you. That's what I was trying to get at. So in her communication, she made it clear that you were mistaken about which weekend was yours and which one was her. Once you received that communication from her, did you attempt to exercise parenting time on weekends that she made clear she believed were your weekends?
I did not, Your Honor. I had at that point submitted the parenting time requests, contacted the friend of the court seeking guidance, and they told me to continue filing parenting time requests and that eventually the court yourself would have to make a ruling on it. And then,
so what I don't understand is if she's making clear that yes, you are entitled to every other weekend, but it's a different weekend, why wouldn't you appear and try to get your child on the weekend that she is telling you is the correct one? Why would you just file parenting time complaints and forego seeing your son for such a lengthy period of time?
so for 2 reasons, Your Honor. First and foremost, I was advised not to continue because the determination that she made was not it was not enforceable. So she is just she picks and chooses when she thinks things work for her in her best interest. So I was advised that because she is trying to claim that Lucas's parenting time with me must match her other 2 orders, which is not the case, that I needed to continue to file parenting time complaints and I would be hopefully awarded makeup time.
Well,
And
Mr.
Your Honor,
Stinson, what I would have done if I were you is take the weekends that were available, and then if there's a real problem with that weekend, file a motion to explain to the court why that particular weekend doesn't work for you. And I would certainly have addressed that. But I don't understand why you would just forego seeing your son to make a point.
it was not to make a point, Your Honor. So when I do my calendars and my workload for the year, I base that off of my parenting time with Lucas so that I can maximize time with him. Based on the previous 2 years of schooling, where I get him the immediate first weekend after school starts, I did the same planning for the 2020-2021 school year. So my work schedule is based on that. So to change that because of something that Christy has determined is in her best interest and not anywhere in our order is an issue. And I was advised, Your Honor,
is there a reason you can't exercise your parenting time on the weekend that I've now determined is the correct weekend?
Your Honor, I'm able and willing to have my son as much and as often as possible at the end of the day.
Then that's what I think you should be doing, sir.
So the challenge, I'm sorry, Your Honor.
Go ahead.
The challenge
Go
is
ahead.
that we need something in the order so that I'm not consistently controlled and abused by my ex-wife when trying to seek out parenting time with my son. It's consistent.
And then Ms. Hamilton, maybe you can help me. I don't remember now how we determined which weekend was which when I issued my order. I remember there was conversation about it. I remember that I think it had something to do whenever the weekends ended prior to the summer parenting time, but I don't remember a lot more than that.
I think I can help. I think,
Yeah, and I sympathize with Mr. Stinson that it ought to be very clear what's his weekend and what's not when we resume school after summer parenting time. And if there's something that's creating some ambiguity there, I'm more than willing to fix that.
okay, I think we have to even go back a little step further. The confusion arose because Mr. Stinson somehow developed a notion that instead of complying with the literal language of any of the written parenting time provisions of the judgment, it turned out that last year he had the first weekend after school started. And so that made him believe he gets the first weekend after school starts every year. And he consistently emailed Ms. Stinson saying, our judgment gives me the first weekend after school starts. Look in the judgment, it's in the judgment, but it's not in the judgment. The judgment simply says, and we produced hours and hours of calendar analysis for you in the motion when we first had this before you, Your Honor. The school year alternates weekends, and the parties stop that school year alternating for summer. Mr. Stinson gets alternate weekends, just as though we never stopped summer and did the summer parenting time schedule. The weekends just naturally rotate in their normal course of alternating through the summer. And then if you go by the calendar and you X off every weekend that would be his year around, this year, he didn't get the first weekend after school started. But in addition to that, it shouldn't have been difficult to calculate because he had the last weekend before school dismissed for the summer. It should have been just really easy to calculate. And we produced a calendar for you.
Okay, let me stop you.
Yep.
So if we were to put in an order, language that says the alternating weekend sequence continues even during the summer, even though summer parenting time's being observed, so that every other weekend throughout the summer is Mr. Stinson's weekend, even though it may be during a time when he's actually got full week summer parenting time.
Well, remember,
Can I make
hold on,
Can I
Christy.
make a comment? Oh, go ahead.
You go ahead, Christy, and then I'll follow up.
In the very last order, I believe the language states this very clearly.
You mean the order
order
that I already did?
Yes,
The order
on the
10:15
on the
here.
12th.
Okay, yeah. All right, if it's already in there, then I don't have to issue a correcting order. Let me just look at that,
You're
and
on.
make sure that it's clear. Hold on, let me pull that up. I will give you a chance to speak, sir. I just want to look at this first.
Thank you, Your Honor.
Oh, okay. There's language already in the order that addresses this. There shouldn't be any confusion next school year or
Your Honor,
after a Christmas break or a holiday break or whatever it is.
Your Honor, the ambiguity comes from our original judgment of divorce, and the language there reads, quoting, during the school year, defendant shall have parenting time on alternate weekends from Friday after school or at 3 p.m. until the following Monday morning at 8 a.m. Attorney Hamilton mentioned the normal course of things and all that, and that's great. However, none of that language is in our original divorce judgment of divorce, and nobody in conversations and had mentioned the normal course of weekends. Over an 11-week break, which this year was even longer because of shutdowns and other various things. Over the course of an 11-week summer break, I'm only awarded 4 weeks of time with my son. So the past 2 years, Attorney Hamilton misspoke and said 1. Over the past 2 years, which has now set the precedence, it's been the first weekend after school. It was never a reasoning that if you follow the normal course of weekends or any of that stuff, the reason that I was given was that that Lucas's parenting time must match her other 2 judgments of divorce from other counties in Michigan. That language exists nowhere in our divorce decree. So that's where the ambiguity came from, Your Honor.
All right, well, I understand the source of your confusion. There won't be any confusion going forward because the alternating weekend schedule is one that continues throughout the entire calendar year and has nothing to do with when school resumes, the first weekend after school resumes, the first weekend. It doesn't say precisely that the schedule has to match the schedule of her other children. But the practical reality is, if we stay on this schedule, is that it will. So this is something
Understood.
I addressed at the last hearing. I think it's already been addressed in the order that I've presented. I don't think there's really anything more for me to decide today.
Is there any way that we can that I can get some of that lost time back with my son, Your Honor?
Your Honor, we had attached the text message exchange where Ms. Stinson kept saying, "This is your weekend. Will you be coming to pick Lucas up?" And Mr. Stinson consistently said, "Not my weekend, not my weekend, not my weekend." Those are in the,
I'm not ordering any makeup parenting time. Mr. Stinson, I just find it amazing that on the basis of a disagreement over this language and a battle of wills between you and Ms. Stinson, that you would choose to forego the weekends that she is saying you could have your son. You could have had your son those weekends. You chose not to on the basis of wanting to be right about whatever is the proper interpretation of the judgment.
Your Honor,
I'm not ordering any makeup parenting time. You could have had your makeup parenting time, except it looks to me like you were being stubborn.
Your Honor, that's unfortunate because that certainly wasn't the case. I'm trying to follow the letter and the intent of the order as written. There are disagreements between Christy and I, which will never be resolved. And without somebody there or having it very clear and very clearly defined, it's impossible for me to exercise anything correctly.
All right.
I contacted.
It is clearly defined now, so we shouldn't have any problems on this issue going forward.
There's also the matter of parenting time that and she's had a history of not correctly interpreting the order. So that was kind of the reason I was advised by my attorney not to exercise parenting time. I had filed the parenting time complaints. We had different dates on the docket, which were canceled or postponed or whatever the case, which is why we're talking about it now in December and not back in September or October when it initially came up. So understood. but everything from, at one point, Christy thought I was responsible for all transportation. I've got parenting time that I was denied. The friend of the court referee said, yep, Mr. Stinson deserves this time. And that still hasn't happened. And that's now 2 years old, Your Honor. We were supposed to review parenting time in total a year and a half ago. I've been waiting for psych evals to be completed and scheduled since July of last year when you ordered it. I understand it looks like I was being stubborn, Your Honor, but that is not the case. I miss my son. He cries.
I appreciate that. I suggest you start taking advantage of what I've now clarified is the correct alternating weekend parenting time schedule. There's nothing more for me to rule on today. That concludes our hearing. Ms. Hamilton, you would present an order simply denying the most recent complaint as well, and confirming that the order that I entered on November 12th is the governing order for when the parties' weekends occur.
Your Honor, there is one other thing before you today.
What is that?
Mr. Stinson, well, first of all, I want to clarify so that I can prepare the order properly. Mr. Stinson's order to show cause that you signed on these parenting time complaints is dismissed, correct?
Correct.
Okay. The parenting time complaints are resolved pursuant to the November 12th order. And
Correct.
the other thing that Mr. Stinson has up today, although he didn't serve me with it, I found out from the friend of the court, he filed it with the court, is he's filed objections to the second child support review that you ordered be done by the friend of the court. And those objections are scheduled for hearing today. And the only reason I bring it up is because Mr. Stinson is literally exhausting my client with attorney fees. And it appears to us using these hearings to just, we get prepared, we show up, we file lengthy documents with proof, and it turns out that his complaints are baseless. So if you could take a look, please, at his objections to the most recent child support order, I think it'd be great if we could get a ruling on that today too.
I see a handwritten objection that says number of overnights are inaccurate. My income is inaccurate. Christie's income is inaccurate. Request full review. And let me see. Oh, okay. So I've got Ms. Schuette's summary and proposed order. So let's see. First of all, let's talk about the number of overnights. The support order says 98 overnights. How do you calculate the number of overnights, Mr. Stinson?
I was at 120, Your Honor.
So every other weekend in the year, that includes 2 overnights every other weekend, correct?
3 overnights, Your Honor.
Is it? So you return the child to home or to the school on Mondays?
That's correct, Your Honor.
So you get Friday, Saturday, and Sunday overnights, okay. And let's see, you also get, I'm assuming there's some holiday overnights involved there. Ms. Hamilton, have you
Can I help
looked
with
at the
that, Your Honor?
calculation? I'll, any help I can get, so I want to
Okay.
see
So-
what the issue is.
So initially, Mr. Stinson reported 105 overnights to the friend of the court investigator in connection with the first support review that was done in the spring of this year. Ms. Stinson objected to that.
Well,
it was
wait a
redone.
minute. I don't care what anybody reports. I simply
Okay.
want to know what's the correct calculation under the judgment of divorce for his actual number of overnights.
We use the calculator, the MarginSoft calculator, and we get 95.5. The friend of the court got 98, and we're happy with that. And I can show you step by step how we made that calculation if you'd like, apart from the software.
If I can resolve it today, I think it's in everybody's best interest that I do that. So let's do that.
I do too. Yeah, let's do that. Okay, so the way I do it, which I think is the cleanest way mathematically, it does get us 3 more overnights than the software gives us. But I take 52 weeks in the year, and I start making subtractions for those periods that we know don't follow the alternating weekend schedule. Let me show you what I do. There are 11 weeks of summer. So I first subtract 11 weeks. And that brings us down to 41 weeks to calculate with. However, we got to make another couple of subtractions. We have to subtract 2 weeks for Christmas, because that's dealt with another way as well. So that brings us down to 39 weeks of alternating weekends. But between, and I guess 39 weeks is really what they've got, because they don't have any overnights on holidays. So if you take 39 weeks times 3 overnights, that gets you his school year weekend parenting time. Right?
Okay.
Christy, does he have 4 weeks in the summer?
Yeah.
Minus 11 is 41. Oh, I'm sorry. We have to subtract. It's not 39 weeks. We have to subtract 2 weeks for Christmas. So that brings us down.
You already took 2 out for Christmas.
Yeah, you'd mentioned that already.
Yeah, okay. So 39 weeks times 3 would be 30, 90. I'm doing something wrong. 27. I did something wrong.
I got 117.
Yeah, I get that too at this point.
Plus 28, plus half of the
So-
Christmas break, 28 in the summer, half of the Christmas break, which is typically around 10 days to 14
All right.
days. So that's another.
Hold on a minute. I realize we subtracted some things, but there are some things we got to add back in. What we're trying to calculate right now is the number of overnights that are normal weekends.
Oh,
And
I'm
we have
sorry.
to make some adjustments to that.
Okay, so it's not 39 times 3. It's 39 times 1.5, because he only gets every other weekend. 3 nights.
I was gonna divide 117 by 2. I think that gets us to the same point.
Okay, yes. So you get 57.5. Right, when you do that? 55. 57.5.
I think it's 58.5.
Yes, 58.5. So
Yeah.
then you add in 4 weeks of summer, 28.
28 days, okay.
And then you add in, I guess, for these folks, it's only, he gets half of Christmas. So that would be 7,
Okay,
93. And he gets alternating spring breaks. So we call that 3.5, because it's only every other year.
makes sense.
So that gets 96.5 total.
It's funny that you bring up spring break when I was denied that, and I'm still waiting makeup time.
I'm assuming you want credit for that, sir, though. We're talking
I
about
abs-
support right now.
Yep, yes, Your
Let's
Honor.
stay focused.
I apologize.
All right, so I understand Ms. Hamilton's calculation. It would appear, I didn't add those four numbers together, but 58.5 plus 28 plus 7 plus 3.5. And that yields what, 97?
I get
Thank you.
96.5.
Well, you've got 2.5s in there, so you gotta have a round number, not a half. And Mara's busy running the numbers for me, so I have confidence in that. 97, you said? Okay. So 97, friend of the court did 98. How would you calculate this differently, Mr. Stinson?
I I think I was going with the spring break and holiday parenting time, Your Honor.
Holidays here are only 9 in the morning until 8 at night.
So the holiday time doesn't impact overnights.
No.
So all we're counting here are overnights. It looks like 97 is correct. The calculation puts you at 98. Ms. Hamilton says they have no objection to going with what's in the calculation. So that appears to be adequate. Now, the next thing is it says it calculated your support incorrectly. And let's see how they did that. Or your income incorrectly, I'm sorry. Let's see. Defendant's income verified from his pay stubs, receives 76,1070 per month in base pay. Is that a correct number?
That's accurate, Your Honor.
1776 per month in housing allowance,
That's correct, Your Honor.
and 256.68 in BAS. I'm not sure what that is.
That's a basic allowance for subsistence, so food.
Meal allowance?
Yes,
Are those
yes, Your
numbers
Honor.
all accurate? Are
Those
those
are
numbers all
accurate.
accurate?
Those are accurate, Your Honor.
So if your objection is they calculated your income incorrectly and you're telling me these numbers are correct, I've got a disconnect here.
So
What's in,
I don't remember the law off the top of my head. MCL 5-04 something. There's a clause in there that states that military members who are supporting another household, and I'm remarried with a new baby, BAH is not to be calculated. That BAH is for my family, not for support obligations. So if I were, and I've used this before, if I lived next to a base and lived in on-post housing, the Army has a responsibility to provide me housing, provide my family housing, and that's what that is for. So I'm not sure if
hold on a minute. I just wanted to see if this gave you credit for another child. How old is this child?
it's about 7 months old, Your Honor. We also have 2 other children in our home too. Your Honor.
Hold on.
It's
Oh, okay, I
page
see.
2.
It gives you credit for another child. I just want to make sure it did that.
Okay.
And it does. And it gives the mother credit for 2 other children. So that's included. And I'm not familiar with whatever it is you were just referencing. Ms. Hamilton, are you familiar with the provision he just referenced?
I'm not, I attached all of the law that we could find that applies to BAH to our original motion on this issue, and from the child support formula itself, it indicates that BAH is fully considered. In addition, Your Honor, I should point out that it is non-taxable. And his entire $100,000+ income, because he's military, is exempt from Michigan state tax. So however you cut it, he gets the benefit of every doubt.
All right, well, yeah, I mean, Mr. Stinson, you're telling me that you are aware of a specific provision in the Michigan Child Support Guidelines that says if you're getting BAH, but you're responsible for the support of other children, that your BAH is not to be included?
Yes, Your Honor. I've got it on my computer. I'm trying to pull it up right now. And then I can quote the actual law.
All right, I'm willing to take a look at that.
This should have been in a brief submitted within the 21 days allowed for the objections to be filed, Your Honor. And I object on that basis. We ask that you dismiss his complaint because it was insufficiently detailed to allow us to submit an answer.
I don't have any strict requirements for objections. When people file an objection, I hear the entire objection, whether they spelled it all out or not. And I'll certainly give you that opportunity to respond to it.
Okay, thank you.
I don't require briefs with objections.
Can I make a comment?
Please, may she?
Sure.
Thank you.
This was the same argument that he presented the last time that we had a support review, and you had actually ordered this review based on this other argument that he's presenting again. This review right here was to include the BAH and the BAS.
If the past calculation was incorrect for including the BAH, and the current one includes the BAH and it shouldn't have, he could certainly make that same objection again.
That's
But
why
I
you
need to
ordered.
know.
That's why you ordered
I
this
need to know the
review.
basis. My recollection is that they failed to include it the last time.
And
But
yeah.
if they included it improperly, that would be a different objection, and I'm willing to consider that objection.
You actually looked at our legal material that we submitted, Your Honor, and you ordered the friend of the court to make the calculation, including the BAH and the BAS, and that's in an order.
I understand that, but I don't remember having any awareness at the time that when someone is responsible for the care of others, that impacts whether or not the BAH should be included. And if Mr. Stinson has authority to suggest it was improperly included, I'm going to consider that. So, Mr. Stinson, I've got some other people waiting, and I know it's going to take me a while to get through some of these other hearings. I am
Yes, Your Honor.
I'm willing to give you some time to submit whatever it is you think you found that would protect all or a portion of your BAH, but you need to submit it to me and to Ms. Hamilton so that Ms. Hamilton has a chance to respond to it. And if I find that what you've submitted is a valid objection, I will make the correction required by that once I've considered Ms. Hamilton's response.
Thank you,
So
Your Honor.
the last issue involved, as you said, they calculated her income incorrectly. So I
Yes,
want to
Your
know
Honor.
what you're referring to there. I've got, they calculated her monthly gross income at $2,504.67 a month. What is inaccurate about that, sir?
So I believe in my previous attorney was supposed to subpoena Ms. Hamilton as her employer to validate and verify that what they are claiming Christy is earning is actually what she's being paid. So I'm not sure where that subpoena ended up or what the case is.
I don't know anything. Let me see what they said they considered for her income. Plaintiff mother earned $17 per hour, 34 hours a week, multiplied by 52 weeks. It doesn't say what documentation the friend of the court relied on. It says, oh, okay. It says plaintiff mother's income was derived from the last support review completed January 27 of 2020.
To which I provided pay stubs for.
All right. And are you still making the same amount?
I am.
Still working the same number of hours per week?
Actually, she got a raise since you're not at $17 an hour anymore, are you? We downloaded the payroll records that we submit to our employer for Michigan tax reporting purposes, which is the only information that exists and is accurate. But I think you got a $1 hour raise since then, did you not? Or was that before your raise?
I don't remember.
That's something that we could submit to the court within 24 hours if we needed to.
Why don't you submit a current pay stub that shows current hours and amounts, and I will certainly take that into account.
Just so that the court knows when her income was requested, 100% of her income was submitted right off our payroll records, and it was accurate at that time. And I don't think she
I
was,
understand.
yeah, okay. Oh, just so it doesn't look like she's pulling shenanigans.
I understand that.
Okay.
I'll just make sure we use current information documented from a pay stub, just as Mr. Stinson's was calculated from a pay stub.
Okay.
Then
And then
the
if there
final,
are- Go ahead, sir.
the final thing that I have in terms of her income, Your Honor, is, and I'm not sure how, we talked about my income and taxable versus non-taxable dollars. I know that she receives a significant amount of money in other child support orders, and I'm not sure how that plays in, but if you mentioned a minute ago that she gets credit for 2 additional children, I don't know if that additional income plays into it or not. And then finally, I am never allowed to have the tax benefits of having my son. She claims him every year on taxes. So I think that should be considered part of her income as well, because she gets the tax break, whereas I do not.
Most child support orders take that into account. I'm assuming this one does.
It does not, Your Honor.
The formula does, Your Honor. It shows up on the calculations in terms of the number of exemptions.
That was my understanding.
And in addition, child support for other children isn't considered under the formula.
And I'm aware of that as well. All right,
So are we
I will
gonna-
consider all of this information, and if I believe an adjustment in the support order is warranted, I will order that.
There's one hanging detail. Does this mean we're doing a third support review to reflect Ms. Stinson's $1 an hour raise?
No, I'm doing it myself, so
Okay.
there won't be any ability to object.
Okay,
The only ability will be to file a motion for reconsideration or appeal my decision, but there won't be another support review done by the friend of the court.
can we have a deadline by which Mr. Stinson needs to get me the information that he believes is legal authority for excluding the BAH from the child support calculation so that I can plan
Sure.
for responding?
Sure,
7
Mr.
days.
Stinson, is 7 days sufficient for that?
It is, Your Honor.
And then can
Okay,
I
let's do that.
have, since it's going to be Christmas then, can I have 14 to respond?
I'm okay with that, but whatever support adjustments I make will still be effective, whatever the effective date should be.
And Mr. Stinson, I'm going to have to serve you with our order today. So I need an address where you want that sent. It has to be spoken on the record.
It's the same address that it's been. It's 9392 Dixon Road, Rives Junction, Michigan, 49277.
Thank you.
All right, I'll watch for that information and we'll issue a ruling based on what you submit. Thank you.
Thank you, signing off.
Thank you, Your Honor.
You're
Thank you.
welcome. You're welcome. And Ms. Reynolds, I brought you in by mistake. I think what happens is as I click on people to let them in, there's a little bit of delay. So I'm going to put you back in the waiting room.
Oh, okay.
And the person I meant to bring in was Ms. Burks.
Can you hear? No.
Okay.
Turn the computer around.
This is a matter of Bofizel versus Bofizel. And let me make sure I've got everyone here.
Judge, I'm just adjusting one computer. I'm Charles Kronzek. I'm here on behalf of Sarah Bofizel. And if you just give me a second here, I'm going to get her in here for you too.
She's actually just logged into my, oh, okay, you're both at the same spot, I see.
Yes, sir.
Yes, sir.
Just give me 1 second.
Give me
here.
one second here.
All right, so Mr. Kronzek has stated his appearance. Ms. Burks?
Yes, Your Honor. Tiffany Burks on behalf of Bridget Bofizel.
All right, and I believe we are here on her parenting time complaints, correct?
Correct, Your Honor.
All right, and I know these have been pending for a long time, but they were certainly timely filed, so I'm going to address them today. If you could present Ms. Burke's testimony to establish the violations.
Yes, Your Honor, I can do that.
Ms. Bofizel, would you, I'm sorry, Ms. Bridget Bofizel, would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
State your full name for the record.
Bridget Bofizel.
You can put your hand down. Go ahead, Ms. Burks.
Thank you, Your Honor. I'm going to call you Bridget. Is that okay?
That's fine.
All right. You filed parenting time complaints in this matter. Is that correct?
Yes, I did.
Okay. And can you explain to the court the basis of your parenting time complaints?
The parenting time is, as far as I'm understood, supposed to start immediately after school or work. Several occasions, multiple occasions, the time has been delayed substantially, and parenting time has been refused until Sarah has decided to make it happen.
Okay. And explain what your parenting time arrangement has been.
Okay. The parenting time order orders the midweek parenting time to be on a weekday. If we cannot agree, it defaults to Wednesday. It has been from Avery's out of school at 11:30. Sarah shows up at noon, and it concludes at 8 p.m.
Okay. And when you say she shows up, where does she show up to?
The McDonald's in Whitehall.
Okay. And why that location?
that's the only location that she will meet me at to exchange Avery. She will not allow me to pick Avery up from school on her school days, which are Wednesdays.
Okay. And is it every Wednesday at 12 o'clock that you've been getting Avery?
On my work days, I have an alternating 12 schedule, so I work every other Wednesday. I asked for those days to be changed, but that was refused also. So I get McDonald's at 5:40, 5:45, and wait for Sarah to arrive. She generally shows up at 6 p.m.
Okay. So I just want to clarify. You're saying on alternating Wednesdays, you get Avery at noon, but she gets out of school at 11:30 a.m. Is that correct?
Yes.
Okay. And then on the alternate Wednesdays, you get her at 6 o'clock p.m.
Yes.
Okay. And has there ever been a time that you've been able to pick her up immediately after school?
No.
Okay. Your Honor, I believe that establishes the basis for the parenting time complaints.
All right, and the provision is in the judgment of divorce, I presume?
Correct, Your Honor. The judgment of divorce references the Jackson County friend of the court default schedule, which states every other weekend from Friday at 6 to Sunday at 6, and then midweek parenting time from immediately after work or school until 8 p.m. each and every week.
We're getting some feedback. It's probably coming from your office, Mr. Kronzek. Well, that would be my guess. If you've got two, if simply you could mute your two microphones, I might, until it's time for you to speak, I think that'll probably solve the problem.
Yeah, I thought that I would sidestep the problem by wearing earbuds. I am not using a speaker, but I will mute mine. Give me 1 second.
Let's see if that fixed the problem. All right, looks like it is. When it's time to talk, you can just unmute. So, all right. So the judgment of divorce incorporates the friend of the court reasonable rights of parenting time.
That's correct, Your Honor.
So I'm looking at page 14.
Mhm.
I see the Friday at 6 until Sunday at 6 midweek, immediately after work and or school until 8 p.m. Okay, so Mr. Kronzek, do you have questions for Ms. Bridget Bofeisel?
All right, Judge, I'll try to do well. I'm going to just put these earbuds off and hang on for 1 second.
I think let's try that.
Okay. Can I go ahead, Judge?
Yeah, I think the problem is Ms. Sarah Bofeisel, can you hear over Mr. Kronzek's computer?
Yes.
If we could turn your speakers off at your end, I think that's what's creating the feedback because the two of you are in the same room.
Are you
there should be a feature to turn the speakers completely off on that computer.
Let me see. Let me try something. All right. Are we good now?
No, we're still getting feedback.
Okay.
I think you're going to have to make that correction on the computer that Ms. Bofeisel is on.
I can't hear from your phone.
How we doing, Judge? Is this any better?
I think that did it. Thank you. Go ahead with your questions.
Let me just get this turned around. Judge. Is it okay if I call you Bridget as well?
Yes,
Thank you. Bridget, is it true that you have relocated from your prior residence in Redford, Michigan, and you are now somewhere around Rockford, Michigan in Kent County?
yes, in Rockford.
And is it true that after you relocated from Wayne County to Kent County, that you and Sarah reached an agreement to deviate from the court's order?
No.
Well, you understand that the court order is to do your parenting time exchange in Portland, Michigan?
Oh, that's okay. The exchange location. I thought you meant times.
Well, we'll get to time soon, but suffice to say that it's been a long time since the two of you complied with the court order.
As far as the exchange location,
Well, I'm not limiting it to that, but certainly you haven't complied with that portion of the court order.
correct. We have not met in Portland at all.
And that's because subsequent to you relocating to Kent County, you and Sarah had some discussions about deviating from the court order?
Our discussions were based on our weekend or overnight exchange location.
I just asked if you had subsequent discussions about deviating from the court order.
We have had discussions, yes.
And you've also, in addition to discussing deviating from the exchange location, you've also discussed changing pickup or drop-off times. Is that accurate to say?
I guess I need some clarification on when you're talking about, before moving or after. Sorry, you keep going in and out.
If you can raise your hand or something, if you can't hear me,
Okay.
we'll figure it out. I don't know.
Mr. Kronzek, let me tell you, your microphone is fading in and out. You go from being nice and loud to being very soft, and I'm having difficulty hearing all of what you're saying as well.
All right, I'm going to hold my phone and hope that does better. Can you hear me okay now, Judge?
Sounds much better. Thank you.
Okay, well, let me know if I go soft on you here. So in terms of clarifying timeframes, I'm talking about the time after you relocated to Kent County. And just for the record, would you tell the court, please, when it was that you moved from from Wayne to Kent County?
October of 2019, I moved.
Okay, and
Moved in.
okay, and so after on or after October of 19, did you and Sarah have subsequent conversations about being flexible and changing pickup or drop off times?
Not to my knowledge for midweek times. Do you want me to expand on that at all?
Well, I think I'm hearing you say that you had discussion about deviating, but perhaps not relative to the midweeks.
I don't want to answer line here, so I'm trying on what I answer. We had discussions on changing the location because of me moving. And then we had to change the times of the midweek because I moved as well. Because I no longer was driving 3 hours each direction to make a midweek happen.
And isn't it also true that you have in fact emphasized to Sarah in writing the need for her to maintain flexibility either for your personal or work related needs?
Yes, absolutely.
And when you did that, were you also intending that you would likewise maintain that kind of flexibility?
Yes, I'm absolutely open to that.
So let me ask you then about, if I'm understanding the issue that you bring before the court today, the FOC handbook, which the judge referred to in his parenting time order, indicates that your parenting time would begin immediately after school or work, and that Avery's school recesses at 11:30 a.m., and that Sarah shows up for the exchange at or about noontime. Am I saying that all correctly?
Yes, a majority of the time she's there at noon.
Okay. And that's really the issue that you're before the court about today, is that she's showing up at noon opposed to 11:30.
Correct. There were times where Avery was in school, and then there were times that Avery was not in school. And then there were times I was at Avery's school at the school's request on those days as well.
All right. Now, the McDonald's that you two have begun doing your exchanges at is approximately what distance, drive time wise, from Avery School to that McDonald's?
About 15 minutes.
And you would anticipate then that if Avery walked out the front door of her school at 11:30, she would not be at the exchange location immediately after school. Is that fair to say?
If she was transported from the school to the McDonald's, yes, it would take about 15 minutes.
And so you don't have an expectation that the word in this case, the word immediate literally means immediate within 1 minute, 2 minutes, 5 minutes. You anticipate there's some drive time between school and your McDonald's location?
I anticipated picking her up from school.
And is that an agreement that you and Sarah made when you agreed to use the McDonald's location?
Avery was not in school when we made that agreement.
But my question was, did you agree to the McDonald's location when you stipulated to the McDonald's location? Well, of course you did, because you signed the stipulation. Okay, so it's been McDonald's for a long time,
Prior to Avery going into school, yes.
and it continued at McDonald's subsequent to Avery going to school?
Yes, against my wishes, but yes.
But nonetheless, the two of you reached that agreement, and that's how it's remained. Are you not hearing me?
You're starting to go in and out again a little bit.
Sorry, yeah, thank you for raising your hand. So it's been McDonald's and it continues to be McDonald's. And your concern is that the exchange hasn't been immediate at 11:30, yes?
Correct.
Okay.
Or-
And that-
yeah.
Okay. And again, you yourself have asked Sarah to change parenting times as well.
I've asked her to go to utilizing what is outlined in the friend of the court handbook.
And that being immediate in the literal sense of the word, immediately after school?
Yes.
Understood. I don't have anything further, Your Honor, for Bridget Bofaisel.
So let me, the issue here is Bridget, and I'm sorry for using your first name, but it's confusing if I do anything else. Bridget wants to pick the child up at school on the midweeks when she is available immediately after school. Why is that a problem?
Well, there are other problems associated with that, and I'm happy to have that discussion if the court wants to talk about it. But
I do want to talk about it because I think that might resolve this particular problem.
yes,
That's what usually happens for parents who have a parenting time schedule that starts immediately after school is they pick up their child from the school. That's commonplace. Why shouldn't Bridget be allowed to do that?
Yeah. Well, one of the issues, and I'm going to let Sarah answer that, but one of the issues is the frequency or lack of frequency with which Bridget actually does the exchanges. So sometimes she does, sometimes she doesn't. So there have been at least 2 other people that have done the exchanges, and keeping in mind that we're dealing with a small rural school and a 4-year-old child, and the primary custodian, Sarah, who's not permitted to know anything about who's going to show up and all of those sorts of things. But I'm happy to have my client address some of those issues with you if you would like.
Can I just fix that by saying that when the child is picked up from school, that Bridget, it needs to be the one that picks her up from school and not send somebody else because of the confusion that would create at the school? I mean, is that something that you're okay with, Bridget?
I actually had a meeting with the principal just to kind of have an introduction and a face-to-face because we hadn't really had one. And with me went my spouse, Kristen, so that the principal and the teacher and everybody could meet Kristen as well. The principal and the teacher are both familiar with her. And at times I may get stuck in court. I may get hurt. Who knows, what might happen. Kristen is the only other person that has picked Avery up. And both the school and Avery are extremely familiar with Kristen. So I would really appreciate that flexibility, really just because of the nature of my job.
And you said spouse, so the 2 of you are married?
We are not yet married. No, we are engaged. COVID kind of derailed some plans on that.
And in addition, Judge, again, a part of the issue here is just the refusal to communicate at all. I'm delayed at work, I'm on a call, I've been injured, whatever it might be. I can't show up at noon. I'm going to be 1 o'clock. And my understanding, Judge, is that very thing happened last night. That Bridget, for reasons that I don't know about, and I don't care, I mean, it's none of my business, but she was delayed. She was kind enough to call Sarah and say, I'm delayed. Sarah said, fine, just let me know when you're undelayed and I will get to McDonald's. I'm going to be flexible. That's all it takes is a phone call.
Okay, I get that, and it sounds like that worked last night.
It did not.
Oh, okay. Well, fair enough. In any event, let's stick with one issue, and that is whether she can pick up the child from school, directly from school. Why shouldn't she be allowed to do that?
Sarah, is that something you want to address with the judge?
I'd feel confident if you would like to, or I can, whichever.
Yeah, Judge,
Whichever you would
do you
prefer.
want to hear from me or do you want to hear from Sarah?
At this point, I'm just trying to see if I can't resolve this without spending the rest of the afternoon taking testimony.
Yeah.
It seems like a pretty simple issue. Just what's the objection?
Yeah, if Bridget will pick her up, that's great. If Bridget will just pick up the phone or call or text or something and say, I'm delayed a half an hour or I'm delayed indefinitely, I'll give you a heads up 10 minutes in advance or any of those things, we will make that work. If Bridget will just call or text or something.
Obviously, the child can't be left at school.
Sarah,
the child needs to be picked up at school when she's done with school. And if Bridget is delayed and can't be there, obviously, and I need to talk about the other issue of whether her fiance should be allowed to do the pickup. But assuming that Bridget can't be there and nobody else suitable can be there, there obviously needs to be a heads up to Sarah so she knows that she needs to pick up the child. I mean, that
And
just,
she will.
I get that Bridget's involved in law enforcement and things happen where your plans get upset. I get that. But it sounds to me like we have an objection to anyone other than Bridget doing the pickup at school. So I want to understand that. It shouldn't be just anybody showing up, but if she's in a relationship with another person and that person is known to the school, I personally wouldn't have a problem, and known to the child. Obviously, we don't want the child being picked up by a stranger. Why couldn't that person be the alternate? So either Bridget or the fiance be allowed to do the pickup. So it sounds like there's an issue there. Let's address it.
Yep. So I think the issue is Avery and letting Avery know in advance who's going to be at school. She's, as I understand it, of course, I don't know Avery. I am told that she wants to know what day she's at this house, what day she's at that house, who's picking her up from school, what's for dinner, all those sorts of things. And that if it's not Sarah picking up Avery and she's due at Bridget's home, it's Bridget's midweek or whatever, that Bridget actually be off work and available to do parenting time as opposed to abrogating her day, her parenting time to the girlfriend.
All right. So the issue isn't just pickup. It's the issue is who's actually going to be exercising midweek parenting time.
Yes.
I get that. And you're advocating for the position that if Bridget's not going to be the one to be exercising the parenting time, that Avery should stay with Sarah.
Yes. And if it's
All right.
if there's a question mark because of whatever, whether it's work related or snow related or health related or whatever, that's okay. Bridget just has to communicate that by text or by phone call.
So Ms. Burks, I'll give you a chance to weigh in on this issue.
Yes, Your Honor. So from the logical standpoint, of course, that makes sense that the parties just simply communicate with each other. But unfortunately, I think as you're aware, Your Honor, that just doesn't happen with these two. It's not communication like it should be. In addition, so essentially, I guess we're talking about a right of first refusal if Bridget's not able to exercise her parenting time personally. So my question then would be, does that go both ways? You know, when Sarah's not able to exercise her parenting time, then, you know, should Bridget be allowed to have that parenting time? Bridget is not routinely failing to exercise her parenting time. There is an occasion here and there where she's not able to do that. And I think a prime example of her communicating with Sarah just happened last night. She was at work, she was on a call and she could not leave. And she communicated that to her. So I'm just not following the argument that Bridget has to personally pick her up. In my mind, it just logically doesn't make sense, Your Honor.
Yeah, and I wanted to make sure I was separating out, is it just someone else doing the pickup because Bridget is delayed? Or is it Bridget's going to have to work the whole night shift and Avery doesn't see Bridget at all during this parenting time, which sounds like is the concern.
Correct, Your Honor. And that did happen one time. I think Bridget would testify to that on one occasion, she was unable to exercise her parenting time. and her fiance had Avery during that time. That's only been one time, and you know, she last night wasn't able to exercise it, so she took this route instead of telling Sarah, I can't exercise my parenting time. Avery can stay with you tonight.
And Judge, I think Sarah's testimony would indicate it's happened on 3 occasions, but last night was good testimony to the fact that communication works. It worked last night.
Well, it doesn't sound like it worked from Bridget's perspective.
Correct.
And I don't know what that is. Here's what I'd like to do. If counsel, have the two of you spoken at all about trying to resolve this? Have you
Yes.
made any attempt to resolve this? And
We have.
you've been unsuccessful.
Correct, Your Honor. There are other issues in this case as well, not before you today, but potentially in front of you very soon. We have been communicating extensively.
All right. Whatever conversations you've had, you haven't been able to resolve the issue of picking up from school.
Correct.
Are all of the parenting time complaints based on the timeliness of when exchanges, or do we have parenting time occasions when parenting time was just outright flatly denied for the entire parenting time?
The complaints are based on the timing, Your Honor.
Okay.
Can I, one thing on there? Sorry.
Your Honor, the form that we have from the FOC says that if this was a if these 5 dates were in fact a denial, the FOC calculates it to be 2.5 hours total. But we don't think that there was a denial for the 2.5 hours because there's been nothing but flexibility. And
I understand. I was just trying to clarify, was there ever an occasion, or we're just talking about the timing of the exchange? Frankly, my inclination, although I'm running out of time today, is the problem. What I was hoping to do, rather than wade through a bunch of testimony, is try to cut to the chase and find out what the problem is. I think picking the child up directly from school is exactly what should happen. That avoids this problem. As to who can do that pickup, is there any concern now that Avery is troubled by being picked up by Bridget's current fiance?
Mm-hmm. I haven't discussed that with my client at all, although I'm not aware of Avery having a problem with Kristen.
So my inclination is to order that the parenting time after school on the alternating weeks where Bridget gets Avery after school, that Avery can be picked up directly from school, either by Bridget or by Bridget's, what's your fiance's name, Bridget?
Kristen.
By Kristen, but nobody else. I don't want anybody else picking her up from school. I only want her picked up by school by someone she knows. So in Sarah's case, there are days when she can't be there. I suspect one of her parents or somebody else who Avery knows might have to do the pick. That's not a problem as long as the school knows who it is and as long as Avery knows who it is. And I think that at least fixes this particular problem. It looks like we've got some other problems that I'm going to have to spend a lot more time wading into and hearing testimony, but at least this can fix that problem. Is that acceptable to you, Ms. Burks?
Yes, Your Honor.
Mr. Kronzek, can Sarah live with that?
Well, we will figure a way to make it happen, Judge, as long as we are going to draft an order to reflect what you've indicated today about these every other week's pickups at school. Can we also get into the order the other weeks, the weeks when Sarah's got an entire day, that the pickup is going to remain inside that McDonald's building?
That's where it's been, hasn't it? That's not a problem, is it?
Yes.
Well,
That is
Your
a
Honor,
problem?
it is a potential problem. The parties have been doing that, but only because Sarah has threatened to make that the McDonald's in Portland. And so Bridget just went along with it.
We're not dragging this child to Portland for an exchange.
Right.
That's absurd.
The reason that it had been on the inside of McDonald's opposed to, say, the parking lot is McDonald's has some security cameras, some video available if we need it. There were some instances where we thought we needed it. So prior counsel and I reached an agreement that they would just do it in the lobby of McDonald's where there were cameras available.
Any reason that shouldn't continue, Ms. Burks?
I'll have to ask my client, Your Honor. I can't speak to what prior counsel did.
Right, but we're not changing. I mean, that's what they've been doing, correct?
It
Correct,
is.
Your Honor.
Well,
They
keep
may
doing what you're doing in that regard, and it can be reflected in an order simply to confirm that's the place and it's going to be in the lobby. And I know there's going to be other stuff coming at me. You've tipped me off to that. I'm happy to address those things when I have time to do that, but at a 3 o'clock show cause, I got 2 people waiting. I've got to deal with them. I think at least for today, this resolves one of the issues.
Yes, thank you, Your
So,
Honor.
Mrs. Burks, you'll prepare an order reflecting this?
Yes, Your Honor.
All right, fair enough. Thank you.
Judge,
Have a good day.
Thank you,
You too.
Judge.
I'll be chatting 1 second.
Maybe I have to.
Tasha, sorry to hold you up.
No problem.
Yes.
Let's see. Okay, we're here on Engblom versus Smith. Ms. Reynolds, can you hear me okay?
Yes.
Okay. Give me just a moment. Sorry, we've had to keep you waiting so long. That last matter took longer than I anticipated. So we are here on Mr. Smith's parenting time complaint. According to the complaint, Mr. Smith, you were denied parenting time on November 11th. Is that correct?
Yes.
All right. And according to the well, wait a minute. Yes, according to the complaint, it says you were denied access to your daughter. The mother failed to drop her off at a new court-ordered location. Okay. All right, so November 11th, what happened that day, Mr. Smith?
I was working, and I had it set up to see my daughter through video chat and everything. My mother was gonna have her, and she just failed to drop her off.
So this is parenting, well, let me find the parenting time order. So you've got, according to the last order, you're supposed to get unsupervised parenting time every Wednesday from 11 a.m. till 3 p.m. and every other weekend from 11 a.m. Friday until 6 p.m. Sunday.
Yes.
All right. And apparently this parenting time has been taking place at your mother's home?
No, well, the Wednesdays have, because I filed to change the parenting time, but the Wednesdays have been going on at my mother's home because I am at work with my new job, and my hours, I work till 3:30. So,
I see. So you don't actually get to see your child on those Wednesdays. Your mother gets to see her.
well, I still see her. I'm not actually there.
Oh, I got you.
I video
And on
chat.
this,
I video chat with her, so at least she does get to see me, because the mother doesn't want to change the Wednesday's time for whatever reason.
I got you. I got you. So what's your current work schedule?
It's 6 a.m. It's 6 a.m. to 4:30 right now until the end of the
All
year.
right. And what's going to happen at the end of the year?
We go back to 6 to 3:30 is my normal schedule.
I see. And it's just extended because there's a lot of work to get out the door, or?
Yeah. I work on the new F-150 window regulators, so they're in need of them.
All right. There hasn't been an issue with well, wait a minute. So 11 a.m. on Fridays for your every other weekend parenting time obviously has been a problem too because of your current work schedule.
Yeah, yes, it is. Well, but my mother, of course, she watches her while I'm at work, and then when I
So
get out of work.
your mother covers for you. Okay. So Ms. Engblom, do you acknowledge that you didn't drop the child off on this date in question, November 11th?
Yes, William's mom texted me not to drop off our daughter due to the fact that Will was going to be working in the past 2 Wednesdays before that. He was not there, and I was unaware of his new work schedule since he does not tell me anything about our daughter's well being. But our daughter was telling me how she has not seen daddy and she seemed pretty upset. So that Wednesday, I asked Will's mom if he was planning to pick up our daughter. She told me no, and it would be better off for me to just keep her so we don't have to disappoint her since he was technically at work. I also sent in those text messages to friend of the court last week. So hopefully they'll get that copy anytime now.
All right, so let's.
Your Honor, that was a lie. I
let-
have my mother here right now who
hold-
says that is a
Hold
lie.
on a minute. Hold on a minute. So I'm assuming this is an unusual time for parenting time to begin at 11 a.m. on a midweek. I'm assuming we have such an unusual time because of whatever schedule one or both of you had at the time. Now it sounds like currently you're normally working during the day, correct?
Yes, I was on a third shift schedule.
And you're going to be working during the day even after the first of the year. You just won't be working quite as late. I mean, typically midweek parenting time takes place after school until 8 p.m. Uh, uh, Is there any reason we can't change that midweek parenting time so that Mr. Smith is home and able to exercise his parenting time?
Is this just for Wednesday? I work second shift, so that's why it's hard. So some days I'm
I
do
got you. So second shift is what, 3 to 11 or somewhere in
I
that range?
2 p.m. to 10 p.m.
2 till 10. Who watch it? I'm sorry, what's your child's name?
Laney.
Laney. I should have remembered that. So who watches Laney when you're at work?
Either my husband or her other grandmother.
Okay. So we clearly have a challenge with your respective schedules. How old is Laney?
She's almost 4
Uh,
this month, so she's still kind of young.
is she in preschool yet or not?
Nope, she'll be in school next year.
Next year, okay. I'm not quite sure. So you're every day during the week, Ms. Reynolds, you're working this shift that you just described.
That's why it's hard. My schedule's it's part-time, so it kind of bounces around. So I work about 4 to 5 days a week, but it's not like a set schedule. So that's why it's a little hard. So unless I can try to talk to my work to try to at least have Wednesdays off all the time, but I don't know what that means for Fridays, if he's trying to change Fridays as well. But I'm also curious too, if the drop off is at grandma's, how am I supposed to know if Will ever picks up our daughter if I'm not allowed to actually see if he forks time? That's why I don't like grandma's house to be the drop off and pick up, because if he was in a public spot, technically his mother can't save his butt. So that's another
Right,
issue.
and clearly Lainey gets disappointed when she's not allowed to see her dad. She wants to see him. She wants to spend time with him.
Yeah, from the last 2 Wednesdays, she was pretty disappointed. I tell her though, we're going to daddy's house. Dad's gonna pick you up. So obviously she's expected to get picked up by dad. And then when he fails, it's kind of hard. But granted, he does have a job now. But through the past,
it's not like he's foregoing his parenting time.
It's kind of hard though too, because he did get arrested on a parenting day back in June. So it's kind of iffy if he's working or if he's doing something illegal.
Mr. Smith, I can barely hear you.
He had called the cops on me after I left to try to pick up my daughter and told them that I had a child support warrant back in June.
And that's why you got sent to Georgia. That's funny. That's nothing to do with child support. I didn't call the cops on you.
Please don't talk to me.
I don't direct your comments to the court, not to each other. I'm just trying to figure out if there's a way we can adjust the parenting time. It doesn't look like there's going to be an easy way to do it. The problem of the PPO and how that impacts all of this certainly complicates things.
Yes, she harasses me a lot for there to be a PPO, Your Honor, and I don't talk to her at all. My mother will abide her anytime she wants to know how Lainey is doing. She will tell her. She does not have to contact me at all. And her contacting me and contacting me and contacting me is not, it's not right with a PPO.
So Well, the PPO isn't in front of me today, but Ms. Reynolds, do you contact Mr. Smith?
I barely ever contact him, and if I do, it's how is Lainey doing this weekend? He just got out of jail, so I was a little worried about my child not seeing her dad for a few months. So I haven't spoke to him honestly, and the last time I texted was maybe 2 weeks ago when he last had her, and I said, "How is our daughter doing today?" But we have a PPO hearing coming up soon, so you'll see all those facts to see how the story really is.
You know what? I think what I'm going to do today is simply adjourn this and hear it at the same time as the PPO hearing. So I'll hear both at the same time. We've run out of time today anyway, and I want to come up with something that works so that minimizes uh, opportunities for disagreements, opportunity for arguments, and maximizes Mr. Smith's time with Lainey so that he gets his parenting time at a time when he can actually exercise it. It sounds like that's something Lainey would like to have happen. It sounds like even something, Ms. Reynolds, that you would like to have happen. The only challenge is figuring out when to do that, that works for both of you and how to do exchanges. So I'm going to adjourn this until when I have you in front of me on the PPO and I have a little more time to devote to it. But I am going to try to fix something to minimize this. This is, Lainey's awfully young. The two of you are going to be co-parenting for a long, long time. We need to figure out a way to get past all of this. And I'm going to try to help you do that. I'm just not going to be able to do it today. All right. So I'm not going to order anything today, but we will address this fully when I have a chance to do it. So sorry we had to cut you short today, but we've run out of time. So as soon as you're back, we'll address these things. Okay.